Hello everyone, my name is Ruby Yadav and I am a legal intern at Lexis and Company. I am pursuing my LLB from Miri Professional and Law Institute, MDU Rohtak. I am glad to get this opportunity to represent myself and discuss my topic with all of you. So today I am going to discuss the topic which is the international dispute under the international law. And the sole purpose of my topic is to tell you what are the international disputes and what are some methods through which these disputes can be resolved. Firstly, we need to know what is dispute. So dispute is a disagreement on a point of law or a fact, conflict of legal views or interest between the parties. So this is a dispute generally dispute is a disagreement on any lawful object between the two parties. Now what is the international dispute? Now international dispute is a disagreement which arises between the two states concerning their relations with one another and with other states. So this is the international dispute. Now there are two kinds of disputes arises in the international law. First one is the political dispute, which is non-justiciable, and second one is the legal dispute, which involves not only the questions of law, but it involves the law itself. So these are the two kinds of disputes under the international disputes. Now there is a term of the Security Council. Security Council shall determine the existence of threat to the peace, breach of the peace, or act of aggression, will take measures to maintain and restore the international peace and security. It is the duty of the Security Council that before making any recommendation on the matter, the Security Council will call upon the parties and ask them to comply. There are two methods through which the international dispute can be resolved. The first one is the peaceful method and second one is the compulsive method. The peaceful method is mentioned under the Chapter 6 of the United Nations Charter, and the compulsive method is mentioned under the Chapter 7 of the United Nations Charter. And it is the advice of the United Nations to firstly try to dissolve the dispute with a peaceful means. In this video, I am going to discuss only the specific means of solving the international disputes. So, historically, the international law has been regarded as an international community to ensure the establishment and preservation of global peace and security. Article 2, Clause 3 of the United Nations Charter provides that all international disputes must be settled by the members by peace-specific means or the peaceful methods, while maintaining international peace, security, and ensuring justice is not endangered. That means the member states have to settle their international disputes, by pacific means. Now, Article 33 of the United Nations Charter provides some of the means through which the dispute can be settled down. We will discuss every method one by one. The first one is the negotiation. In the negotiation, the states can solve their dispute through the diplomatic representatives by a direct discussion and by the exchange of their views. This is the direct method of the negotiation. Second one is the inquiry. Inquiry has no independence existence, rather It is used with other means of solving the disputes of international character. And the third one is the mediation. In the mediation, the third party, the third state tries to solve the dispute between the two states. In mediation, the third party or the third country does not gives only its good offices but participates in the negotiation, etc., with full efforts to settle the dispute completely. That means the third person or the third country gives their 100% to solve the dispute among the two countries. The fourth one is the conciliation. Conciliation means bringing two opposite sides together to reach a compromise in an attempt to avoid taking a case to trial. In the conciliation, a dispute is referred to some committee or commission which presents a report wherein suggestions and proposals are made for the solutions of the dispute. And these proposals or solutions are not binding in nature on the disputed parties. They are completely free to accept and reject those proposals and solutions. And the fifth one is the arbitration. The settlement of dispute between the states through one or more arbitrator is called as the arbitration, and these arbitrators are selected only by the parties itself. The court of arbitration is not a court, is a quasi-judicial body, and the opinions and the solutions of the arbitrators are binding on the parties because they have chosen the arbitrators itself. Now, the sixth means for settlement of the dispute is the judicial settlement, is nowadays confined to International Court of Justice. Submitting a dispute to a pre-constituted international court or tribunal composed of international judges whose tasks are settle claim on the basis of international law and render decisions which are binding on the parties. So these six are the specific means for the settlement of the international dispute, and the compulsive means for settlement of international dispute I will discuss in my another video. That's it for the specific means of settlement of dispute. Thank you so much all of you.